The essential attributes of law. Consider the following statements. Which ones are laws and in what way are they laws? Statement 1. If at the end of a regulation game of baseball, one team has a lead of 10 runs or more, the manager of the team with the least runs shall concede victory to the opponent. Statement 2. Everyone who lives on Dartmoor is entitled to graze their horses on the common ground. Statement 3. Do not drive at more than 20 miles per hour when within 300 yards of a school entrance. Statement 4. Do not steal. Statement 5. A will and testament must be signed by the testator in the presence of 2 witnesses, neither of whom shall receive any gift under the will. Just from those brief statements, you will see that law is a term with multiple meanings. Even if we put to one side the way law is used in the phrases the laws of nature, law as a human institution can refer to the natural law, the moral law, international law, the books of the Old Testament, which contain the law of Moses, the rules of a church, also sometimes known as ecclesiastical or canon law, the religious codes of ethics, think of Jewish law or Islamic law, the rules of a sport, or the laws enforced by the secular authorities in a particular territory. Any attempt to identify the essential attributes of law must begin by saying what kind or kinds of law these attributes are supposed to define. Now, there are 2 different ways in which you can approach a definition of law. One is to provide a checklist of the essential attributes of law. The other is to define law by reference to its central case. Let me explain. A mammal might be defined as a warm-blooded animal which has fur and which gives birth to live young. Now, if that is an exhaustive definition of what a mammal is, then those mammals which do not have fur do not fit the description and definition, and therefore the duck-billed platypus and echidna which lay eggs do not fit the definition either. Turning to legal definitions, how do you define a bank? Banks typically engage in 3 activities: accepting deposits, making loans, and facilitating payments. Does a bank have to engage in all 3 activities to fall within the definition of a bank? A checklist approach would say yes. A central case approach would say it is sufficient if a bank carries out 2 out of the 3 activities. A checklist of attributes, each one of which is essential, may be over-prescriptive, whereas a central case definition, by contrast, identifies certain features as typically present. Where laws exist, they provide human beings with reasons for action as human beings deliberate about what to do. Laws are rules which create or which purport to create obligations. Depending on the content of the law, those who break them may face disapproval, sanction, or the consequence that the actions they take are treated as having no legal effect. The directive force of law is also described as law's normativity. Laws set out norms. They set out what the lawmaker or the community says is the right thing to do or says is the wrong thing to do. There are 6 features commonly identified as either essential to law or as typical of law. Whether you think they're all essential or whether you think they are simply typical of law will depend on whether you have a checklist approach to the essential attributes of law or a central case approach to law. The first feature is this. Laws are rules requiring, permitting, or forbidding action. Legal theorists often refer to laws as norms. Norms are normative statements. They define and divide actions into different kinds. They are instructions about what you ought to do. The second feature is that the rules are presented as authoritative. Advertisements, friends, blogs, all sorts of sources present us constantly with suggestions and advice. But laws are not merely suggestions, opinions, or advice. They claim authority over us. You should follow them. The third feature is that there is an explicit or implicit appeal by the lawgiver to something which grounds their authority. That appeal is one or more of the following: an appeal to the people in democracies, an appeal to God in many kingdoms, an appeal to the fact that the rules are called with right reason and promote the common good Or perhaps even just an appeal to the sheer fact that the rule maker has the power to force obedience, though such an appeal is typically dressed up as the right of conquest or the right of possession. The fourth feature is that the rules are presented as universal in scope. Laws are general or generalizable rules. Laws are not supposed to be ad hoc, one-off decisions. The basic requirement of legality is that like cases are treated alike. The same rule will be applied to anyone who finds themselves in a like situation. The fifth feature is that the rules are recorded. The recording of the rules is one way of ensuring that like cases are treated alike. It's also an indication that the rules have some degree of permanence, that they will remain in place until such time as formal notice has been given that the rules have been changed. And the sixth and final feature of law is that there are sanctions and penalties imposed if the rules are broken. For some legal theorists, this is an essential, if not the essential feature of law. The bad man cares not whether the rules are normative. He cares not whether the rules are authoritative. He cares not by what authority the rules are made. He cares not whether the rules apply to other people or whether the rules are recorded. All the bad man cares about is whether there is a likelihood that he will be caught if he breaks the rules, and about what will happen if he is caught. Other theorists say that while sanctions are often a practical necessity, it is theoretically possible to conceptualize law without reference to sanctions at all. An example sometimes given is of the rules of international law, where there is no body authorized to impose a sanction. Some legal theorists would say that this shows that those international laws are not laws at all. Others say that this proves that there can be laws without penalties. Sanctions would therefore feature in a central case definition of law, but perhaps not in a checklist definition of law.